On Friday, the 25th of February 2022, the much desired and anticipated Electoral Act 2022 was signed into law by President Muhammadu Buhari. And worthy of note is the massive applause and commendations that greeted this singular action from a broad spectrum of Nigerians, including traditional rulers, civil society organizations, opinion leaders, the clergy, and the international community. Though the president signed the bill, but not without some reservations over some components of the bill, particularly Clause 84, subsection 12 of the Electoral Act 2022, which states that no political appointee at any level shall be voting delegate or be voted for at the convention or congress of any political party for the purpose of the nomination of candidates for any election. The president opined that the clause constituted some fundamental defect which is in conflict with extant constitutional provisions. Consequently, President Buhari wrote to the National Assembly seeking amendment of Section 84, subsection 12 of the Electoral Amendment Act 2022. At today's plenary, however, the Senate rejected President Buhari's request, voting no to that request during the voice vote. What is the implication of this development on Nigeria's electoral process? This is our focus today on the program. I am Lydia Ochi. Thank you for joining us. I have two political scholars to join in the conversation, and they are Dr. Ernest Ereke, lecturer, Department of Political Science, University of Abuja. Thank you for joining us.
Thank you very much. Good evening.
I also have joining us via Zoom a legal practitioner, Dr. Kayode Ajulo. We're glad to have you join us.
Oh, it's my pleasure.
Okay, let me begin with Dr. Ernest. What was your immediate reaction to what we saw happen on the floor of the Senate today? The throwing out of President Buhari's request as regards Section 84, subsection 12 of the Electoral Amendment Act?
Well, a lot of interpretations and assumptions may be drawn from that. One is perhaps the enlightened self-interest of the lawmakers themselves. The lawmakers, first and foremost, are politicians who have various political interests and ambitions. And we know that before now, recall the direct primaries that was inserted into the Electoral Act, where the lawmakers insisted that nomination processes would be through direct primaries. Now, there were a lot of conversations and insinuations about that. But then again, it points to the power tussle between state governors and lawmakers also who have a political interest. The rejection of the proposed amendment by the president of subsection 12 of section 84 may also fit into that conversation of the enlightened self-interest of lawmakers, because what if you don't have that particular provision in the law? What it means is that a particular state governor, any state governor, may decide to have as many political appointees as he or she would desire, and then therefore use that to tilt the the processes of nomination of candidates in the favor of the state governor. A president may also exploit that option as well. And so what this helps to do is to ensure that that appointees of the executive, even if the executive has a retinue of aides and political appointees, that these appointees will not serve as delegates in congresses and conventions of political parties. But then one would also agree with Mr. President when he said that it's at variance with constitutional provisions, because there are constitutional qualifications required to contest elections in Nigeria. And given the fact that the new electoral law requires that the processes of nominating candidates comes early. At least it says 180 days to the date appointed for the election. Now, what this means is that those who would want to contest various political offices and who are political appointees currently may have to resign earlier than the constitutionally required date. And so in that way, you would agree with Mr. President that yes, that particular provision, runs, is at variance with the constitutional provision that requires, I think, a maximum or a minimum of about 30 or 35 days, to resign your political office before, that is, if you're a political appointee, to resign that position before you will be able to run in an election. And so in that regard, one may agree with Mr. President, but also looking at, having a fair and free, Congress where everybody is allowed to participate, and then feel that you can participate in this process and have a free run and a fair treatment in the process. So in that angle also, you may want to say that, okay, the legislators were right in rejecting that.
All right. Now, President Buhari's signing of the Electoral Act was greeted with torrents of encomiums. Now, do you think he should not have made that request to the National Assembly in the first instance?
Well, I think it is within the president's right to make that request. And some of us, I particularly encouraged Mr. President to go ahead and sign the bill then, to go ahead, sign it. And if he had reservations and areas where he didn't agree with, then he should send proposed amendments to the lawmakers. And I think it is within his rights, and sending the request to the lawmakers, one wouldn't say the president didn't act correctly. And so he feels strongly that that particular section does not, uphold constitutional requirements, and therefore sending a request to the lawmakers is within his rights. And I would want to agree with him that there are constitutional issues here, but lawyers and the judiciary will eventually help us resolve this constitutional ambiguity, the clash between the Electoral Act and the provisions of the Constitution.
Okay, let me go to Dr. Kayode. We also want to get your own reactions on, your immediate reactions on what we saw today at the floor of the Senate.
My reaction is, I believe that is the reaction of generality of Nigeria. What transpired today at the floor of Senate is to remind us that we are having a government which makes constitutionalism the bedrock of the government. This is a government that believes in rule of law. And if you remember very well, what the Senate did today is to define the constitutional provision as giving them the power to so act to give the law to the people of Nigeria. If you remember, when it took us some time before the president could sign that Electoral Act bill to law, and when signing it, the president, of course, the president is one of the citizens of Nigeria. He has his right to express some misgiving if noticed, or he has been able to identify one, and his duty stop there. And the only thing to do as the president is to request the assembly members, particularly the Senate, to review which is within his ambit as the president of Nigeria. But the question is, can we say what that issue as raised by the president is what is tenable in law? And my position is no, in the sense that there's this law, the particularly section 84:12, has nothing to do with any provision of the Constitution. I say this from the point that what may look a bit closer is section 66, whereas of the Constitution, section 66 of the Constitution only talked about general election, that when it comes to general election, public officers, civil servant, or whatsoever it is, once you are not elected, you have to tender your resignation. But in section 8412. That one is basically on internal democracy, basically on party affairs. And like I said in the letter written to the president, and like I said in the letter written to the president of the Senate, I tried to make it that that's electoral act, the only issue there is to let us know that as a technocrat, as an appointee of the government, you have no business in party affairs. What you have been elected to, what you have been appointed to do, go ahead and do it. And anytime you want to play party politics, either you wanted to vote or you wanted to be voted for, take a leave. That is why, if you notice one thing, that act did not even stipulate the number of years or date or when you should resign. What it states is to take them off any party affairs. And this can be seen in section 226 that gives the assembly members, that is our legislator, the power to make law, to regulate, to manage and maintain political parties and ensure internal democracy. That section is basically on internal democracy. And I think we need to praise and we need to salute the courage of the president and the National Assembly for doing the needful, for following the law and to reject the review of that law. And again, we need to say one thing. One thing is so clear, not that they totally reject it. They take it into cognizance again, the position of the court, that even if there's anything, the court is there to do the needful, to interpret the position of that act and the constitution. So I think it's kudos to democracy today, kudos to our constitutionalism, and kudos to that principle of check and balances that exists between the legislature, between the executive and judiciary. And that was put to it today. And I think we need to salute all of them.
Now, Dr. Ernest, the fact that the Electoral Amendment Bill was already signed into law, is it even possible for any section of the Act to be expunged, as noted by the Federal High Court judgment on Monday?
Well, one is that the lawmakers, the legislature has been given powers to make laws for the country. And therefore, if any law is made at any time and requires amendment, it can be, they have the powers to amend such a law. And so no matter what the provisions are, no matter what the issues are, the lawmakers, the Constitution in Section 4 empowers lawmakers to make laws, for the country. And therefore, even if the president signs a bill today and it becomes an act, lawmakers have powers to still amend that act. But then maybe to just say that the learned Kayode said that the particular provision we are making reference to is only talking about that the constitutional provision talks about general elections. But then the truth of the matter is that you can't participate in a general election without going through the primary elections. And so I think that is the sense, the perspective that the president is looking at. That for you to have access, to participate in the main election, you have to go through the nomination processes of the political parties. And the constitutional, the new law requires that party primaries and nominations will be conducted at least 180 days before the date set for the general and the main election, which means that if I am a political appointee, I would have to resign my position earlier than the Constitution requires in order to be able to participate in the primary election of my political party before I can contest the main election. So I think that is the perspective that the president
was talking about. Okay, now before we go further, we'll take a break, and in this break we'll bring you the scenario, what transpired at the floor of the Senate at today's plenary. Take a look. We'll be right back to continue the conversation.
The Electoral Act Amendment Bill was the first item for consideration on the order paper. There was a point of order by the Minority Leader of the Senate, Enyinaya Baribe, on the bill, and President of the Senate, Ahmed Lawan, provided explanations.
I suggest that the leader step down this bill until he complies with the rules in Order 76.
So on this one, we know that we receive a letter, and the letter is categorical, indicating that the executive wants an amendment to section 84, subsection 12, on the second reading to be led by the leader. In my judgment, should continue.
And then debate for and against the bill ensued.
This provision has been interpreted by the executive arm of government as introducing qualification and disqualification criteria that are ultra-violating the Constitution by way of importing blanket restriction and disqualification to serving political office holders.
At the beginning of section 84, that says that no political party shall seek to disqualify anybody by importing into the process a provision for qualification or disqualification not otherwise provided for in the Constitution.
You cannot be a referee and a player in the same field. It's either you're a referee, yes, or you're a player. It's a settled matter in law that you cannot be a judge over your own case.
Eventually, the bill was rejected.
Those in favor that this bill be now read a second time, say aye. Those against, say nay. I put the question. There was an aye and there were nays, and I said the nays had it.
President Muhammadu Buhari had written to the National Assembly requesting that Section 84, subsection 12 of the Act be deleted.
Yes, that was what happened at the floor of the Senate today, and of course it was bringing about reactions from my guest in the studio, Dr. Ernest. But let me go to Dr. Kayode. The Federal High Court in Abuja on Monday barred President Muhammadu Buhari, the Attorney General of the Federation, and the Senate President from tampering with the Act. The question is, constitutionally, are courts allowed or empowered to mandate the National Assembly on their agenda on the floor?
Thank you very much. Let me answer this question by trying to raise a caveat there as a lawyer and as a particularly practicing lawyer. God forbids that I constitute myself as an appeal to the decision of the either court of appeal or what any court whatsoever, because as long as this matter remains in court, I will really won't like to comment on the particular case of Monday. But as it is, Section 6 of our Constitution has given our courts power to look into issues, and after determining the issue, can make a pronouncement. And one thing we should know is this: asking whether the court has power to pass any judgment or any decision against the president or anybody whatsoever in Nigeria, I will say yes. The court of law, particularly the court of record, has such power. And anytime the court exercises that power, will be tied any lawyer to constitute itself as an appeal. Or when whosoever that feels that they are they did not subscribe to such decision, all that needed to be done is to proceed to court of appeal to overturn that decision, and with the court of appeal uphold that decision is go to Supreme Court, and that is what should be. Because like I said, I won't really want to go into the nitty-gritty of what happened, what transpired, so that I don't really want to prejudice the minds of the court or the minds of everybody. But as it is, the court of records in Nigeria has power to look into any issue and make a far-reaching decision, which I believe the High Court of Abuja on Monday has done. And like what we used to say, we say, as my Lord pleases, as the court pleases. And that should be my response to
Okay, Dr. Ernest, what does this development say of the concept of separation of powers and independence of different arms of government?
Well, one of the things I think we need to understand about separation of powers is that it is not absolute. Separation of powers is not, people view it in absolute terms, but you find that there are certain powers of the legislature that the executive can equally exercise to some extent. But then the most important thing about separation of powers, and I think Dr. Kayode Ajulo tried to talk about that, is the issue of checks and balances within the system, so that no arm of government begins to overreach itself. And that is why the general saying that when you have absolute power, it will corrupt absolutely. And so in order to ensure that there is no absolute exercise of powers, in order to ensure that there is somebody somewhere who is also looking at, overseeing what you are doing, in order not to to exercise absolute powers. That is why we have that idea, that principle of checks and balances within the system, so that the legislature cannot just begin to act the way it likes, feeling that it has absolute powers. The executive will also not exercise absolute powers, so also the judiciary. But then again, for the lawmakers to have gone ahead, to consider the bill and eventually rejected it, even though I would also be careful, as Dr. Kayode mentioned. I think they were also exercising the powers that the Constitution, has given to the legislature.
Okay, let me go give you say my final question, Dr. Kayode. How does this development impact on the electoral process of the country?
The answer can be gleaned from what happened today and what has been. The essence of the electoral process is to ensure that we get our election, we have a credible election, free and fair. And the best way, the beginning of it, is that from that we should ensure that there's internal democracy. Because whosoever that promised to give us the democracy, a credible election, they must be saying that from internally, from the cradle, they've been able to do that. And that is exactly what that section is trying to talk about. To say that we all know that he who pays the piper dictates the tune. Those political orders, those appointed ones, they are already embedded. They are already, for one way or the other. There's no way you can guarantee having an independent mind to vote and to get themselves involved in party administration, particularly going to vote and go. And like what my friend mentioned earlier, that it's like this act is now tying their hand, but forgetting that there's this legal magazine that talked of Valentino fit injuria. You cannot consent to violence and now be complaining that you've been injured. The appointment, it is not a right, it is a privilege. And once you are given that privilege, and if today the law should now say that you should not do anything, they are at liberty to either get involved in party administration, party voting, and that is why you notice that this act did not even stipulate when for them to resign or whether they should come back. All that it says is that as long as you maintain an office, as long as you're an appointee, you have no business with party administration, which I believe is okay. The primary can end tomorrow. They can easily ask those that appointed them that now I'm back, please appoint me back, which to me I believe is fair enough. But for you to be so appointed, for you to be so paid from somebody's, and then to now use that same thing to believe that you want to exercise your vote or any decision. We all know who decision they are exercising. They are more like a proxy of their appointer. And I think that one show that this electoral act is so ready to ensure internal democracy. And like I said, internal democracy is the beginning of wisdom for any electoral processes in Nigeria.
All right. Thank you so much for your reaction there. Now, we've been talking about Senate's rejection of President Buhari's request for the amendment of Section 84, subsection 12 of the Electoral Act 2022. Thank you, Dr. Ernest Ereke, lecturer, Department of Political Science, University of Abuja. We've been educated a lot. Thank you so much.
Thank you for having me.
And also, we're grateful to the legal practitioner, Dr. Kayode Ajulo. We appreciate your insight.
Thank you very much.
And to you, our viewer, Thank you for being a part of the program. Remember, you can still watch this episode and other ones on www.youtube.com/NTA News 24 Hub. Thank you for watching. I am Lydia Ochi. See you tomorrow. Good evening.